for giving us an opportunity. And I also thank Dr. Mahesh, who's the course director for this particular talk. And it is his idea he's very much passionate about this, and he feels, as ophthalmologist, as he said to you previously, that we are all scared, and ignorance is the cause of all this, unnecessary fear. So it is his brainchild, and I think, it is a very earnest attempt in this direction. Now, the topic is, who's afraid of the big bad wolf? Actually, there is a story of the three little pigs, where the pigs, when they don't see the wolf, they keep on playing the guitar and singing, who's afraid of the big bad wolf? Who's afraid of the big bad wolf? And once the big bad wolf comes, you know their reaction. They run, they are like, they are totally psyched. So it is exactly the same position as we are in. As long as we don't get into trouble, we are all very, very brave. And once we have a problem, then only, all our bravery and all our confidence drains off, because we are not aware. It's only ignorance. So the topic for me is, this is a very, very basic talk, and what medico-legal aspects that as a doctor you should know, and what are the implications. So the talk is primer in medico-legal cases for dummies. Dummies means we are not dummies, but as far as medico-legal things are concerned, our knowledge is equivalent to that of a dummy. Now, what is negligence? So, see, as far as medical profession is concerned, you're not expected to know anything. But a person who is a doctor, who should be knowing something, when he doesn't know and when he acts against it, that is when the system of negligence comes. This is one, in my opinion, our healthcare system has failed. When a doctor fails to treat an illness that is treatable. So, because medicine is that kind of a field where, there are no absolutes. Now, like, medical malpractice occurs when a healthcare provider strays from the recognized standard of care in the treatment of a patient. That is all that is expected from you. You should know the standard of care. You should have done the standard of care. If that is not done, then you are negligent. That's all it means. It doesn't mean that, it's a very tough case. There is no diagnosis. You are not able to treat. That is not medical negligence. Now, what is standard of care? It is defined as what a reasonable, prudent medical provider would or would not have done under the same or similar situation. So, see, if you look at this, there are two aspects. It is either commission or omission. Failure to do something as well as doing something which can cause harm to the patient, which is against the standard of care. So that is negligence. Now, what are the medico-legal aspects? So what are the headings under which you can be held liable? Now, so there is a term called tort. Tort means actually in Latin twisted. It means twisted. Tort means basically civil liability. Now, what is a civil liability? Like, I have a right, somebody has a duty. When I have a right, somebody has a corresponding duty. So when somebody doesn't do his corresponding duty, my right is infringed. Okay? And there comes the tortious liability. And the remedy for tortious liability is damages. Damages means you give money. Like, my right has been infringed, you give some money and that is settled. So that is civil liability or tortious liability. And second is criminal liability. It comes under the Indian Penal Code. And the third one is Indian Contract Act, because, when a patient comes to you, there is a contract between you and the patient. Okay? But the importance in Contract Act is the damages is pre-decided, unless in the tort where the damages are unliquidated. So I'll come to that later. And the Consumer Protection Act. Consumer Protection Act is also a form of tortious or a civil liability. The importance of Consumer Protection Act is it is a quasi-judicial system. So if you look at the tort, you have to go to an actual court and do it. But here, the government has appointed a quasi-judicial system. There are no formalities like in a court. It is fast-tracked, and things become much easier to the consumer. So if you look at that, Consumer Protection Act or Consumer Protection Courts have been set for the consumers. They are not for the doctors. It is for the consumers. It's a consumer-friendly forum. That is what you should understand. Now, negligence as a tort. See, these are the things, commission or omission or whatever, which can cause a damage to the patient. And it is unliquidated. Unliquidated means the patient can say, I want 20 crores. Now, the judge will decide how much amount the doctor has to pay or need not pay. So, unliquidated damages means the damages are not pre-decided. So, it depends on the claim and it depends on the evidence and all that. The judge is going to give an order of what are the damages. Now, as a breach of contract, it can be an implied or an express form. Like, suppose you are doing an IOL, you charge 50,000 rupees. Now you are not able to put an IOL. Still you take 50,000 rupees from the patient. So that's a breach of contract. You're not. So here, the damages are liquidated. 50,000 rupees putting in the lens. So if you don't put the 50,000 rupees, no need to pay 50,000. So that is the difference between a tort and the contractor's liability. Now, negligence of crime, see, as far as doctors are concerned, it is very, 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 very rare. Only in extreme cases, like 304A IPC, which says a death of a patient to a rash and negligent act. That act should be so rash, so negligent that, even a first standard child will say that person is wrong because of how mainly it happened. So that is what. Now, negligence under Consumer Protection Act, as I said, it is a civil wrong. Now, res ipsa, this is another condition where the truth speaks for itself. Suppose somebody is doing a surgery, he forgets the scissors inside the patient. Normally, the patient has to prove that the doctor is wrong. But here, the truth is speaking for itself. In this case, the doctor has to prove, like, how the scissors came inside. If he is not convincing the judge or something, he will be held liable. So this is a very, very difficult situation for the doctor where the roles reverse. Just like in a rape case, the person who has raped has to prove that, that he has not done any wrong. It is something similar to that. So these are the liabilities. I said civil liability. The importance of civil liability is there is something called as a vicarious liability. Suppose you are working in a hospital. Now the patient who claims damages, he knows this doctor, if I ask for 20 crores, he will not be able to pay. So what he'll do? He'll keep the director of the hospital responsible. He'll keep the chief doctor or the person in charge of the department also responsible. That is vicarious liability. So it is under their supervision that this work is being done. So if the particular doctor does wrong, they are also held responsible. That is so that the claim can be increased and the patient can claim more and more damages. So that is the importance. Now, criminal liability, as you said, it is not very common. Only in the rarest of the rare case that, a criminal liability comes upon a doctor. Usually, it doesn't come. Now, there is another thing. Error of judgment is not negligence. Suppose a person comes. He has he has got typical symptoms of gastritis. Okay, you give him some Gelusil and wait for ECG. Suddenly, the patient dies. Now, you cannot say it was MI, why didn't you not diagnose? Because given the circumstances, a reasonable person would have diagnosed this as gastritis. Okay, so that's only an error of judgment. That is not negligence. So that is the difference between other professions and medical profession, because there are no absolutes in medical profession. It depends on. And you cannot say that a very, very, very expert cardiothoracic surgeon and a very normal cardiothoracic surgeon, you cannot really compare, because these are all human things. That expertise, it can be only be expected of, a person can be expected of only of a reasonable expertise. Okay. Now, suppose now we have a lot of case laws describing all these things that Dr. Mahesh will describe. There are some nuances that he'll describe. Now I'll tell you a very practical aspect. Suppose somebody gives a case against you, a practical thing. What will you do? That is the thing that I'm going to talk about. Now, why a case happens is it is because of communication gap, stray comment, unfavorable outcome. Communication gap means you have told the patient, you have not told the patient, or the patient has not really understood what you have told. Patient has got a macular scar, you tell him macular scar, after doing IOL, your vision will not improve. Patient says, okay, after surgery, vision has not improved. Now the patient says, you have done IOL surgery, my vision is not improving. So there is some communication gap. The second one is a stray comment. Suppose a patient is not happy with you, he goes to some super specialty hospital outside our state. And one PG there will say, see who has done all this nonsense, what is happening. That is enough for the patient to give a case against you, even though you are not wrong. And the third thing is, it's unfavorable outcome. Now, where is it usually filed? You see, whenever you have a whenever a patient has got some grievance with you, he files it in the Consumer Protection Court or Consumer Protection Forum. It is because if you file a civil case, you have to pay 10% of the damages. You have to deposit it in the court. Suppose you are asking for 1 crore, how much amount of money the person or the plaintiff or the complainant has to deposit. And if he loses the case, that money is gone. But in Consumer Protection Forum, the importance is, see, up to 50 lakhs. Okay, so this is what, I'll come to whatever I was saying later. in Consumer Protection Forum, the amount of money that you have to pay is very, very, very less. You don't have to pay. Up to 5 lakhs, you don't even have to pay any money to, file a case in the Consumer Protection Forum. So it becomes very, very easy for the patient to claim for damages rather than going to the civil court or some other body. So, see, suppose, a person has got a complaint against you, where is he likely to file that case? So there are two things. One is called the pecuniary jurisdiction. The other one is territorial jurisdiction. Suppose damage has happened in one particular place, or it has happened in a particular hospital in one area. The patient can file the case in that particular area where the event has happened, or he can file the case in the place where the doctor or the defendant is residing. And with the new Consumer Protection Act of 2019, even it can be filed in the place of choice of the plaintiff, close to his house, close to his workplace. So it is all favorable to the complainant. That is what I was talking about. And the other one is the pecuniary jurisdiction. Now, if the claim is above 2 crores, they have to file it only in the National Commission. They cannot file it in the District Commission. If the claim is between 50 lakh and 2 crores, you have to file it in the State Consumer Protection Forum. And if it is less than 50 lakhs or up to 50 lakhs, you have to file it in the district forum. So only in the district forum, the territory comes into place. See, each district has a consumer protection forum. If the claim is less than 50 lakhs only, the place where you have to file comes into play. If it is more than 50 lakhs, there is only one state consumer protection forum, and there is only one national consumer protection forum. So there the territory doesn't come into play. So if they claim for more than 2 crore, you have to go to Delhi to fight the case. So that is the importance. So this is what, why should you file in a consumer protection forum, all these things. And time bound, actually they say you have to, the case has to be, the case has to be completed within a period of 6 months. That is what they say. Normally it doesn't happen, but that is the recommendation. And the person who's filing the case can be his own lawyer. Even he can fight his own case. And no, the complaint need not follow all the formalities. You can write in a plain sheet of paper and give the complaint. The judge will accept. So the ease of giving the complaint, less amount of money for registering the particular case, and the place where the case is going to be held, it's all favorable to the complainant. So that is why everybody, they file the case in the Consumer Protection Forum. If you file a civil case, it will go for years. Maybe only your grandchild will get. But in the Consumer Protection Forum, it's time bound. So that is why everybody files a case, even though they have a lot of other options. Now see, this is the fees that one has to pay in the consumer. Up to 5 lakhs claim, no need to pay anything. You can file. I can file a case against somebody. He has to run around. There is no expenditure from your part, and you can fight your own case also. No need to pay for the lawyer also. And up to 5 to 10 lakhs, only 200 rupees. You have. See, for about 10 crore, only 7,500 rupees you have to give as court fee. Just imagine. That is why everyone is very eager to file cases. Like, it's like that. So that is the importance. Now, there is something called as limitation period. There is a concept called cause of action. Cause of action means, what is the act that has led to the particular damage. So when it begins, suppose a surgery, there is a complication and there is some damage to the patient. So the moment the surgeon starts doing the surgery, that is the time when the cause of action starts. Okay. So if the cause of action and the time of filing the case, the period is more than 2 years, then according to theory, the person cannot claim for damages in the court. That limitation period is over. There is something called as a Limitation Act, which tells you for each and every case how early or how late you can file a case. So the limitation period for consumer protection in the Consumer Protection Act is 2 years. Okay. But what happens for a minor? Suppose an ROP case. You have done laser. Unfortunately, the vision is gone. See, the person has an option of becoming a major, and then only the limitation period will start. So you do an ROP case, the vision goes. 18 years you have to wait to know that whether he's going to give a case or not. And after 18 years, 2 years, he still has got to file a case. Now the parent can immediately file the case. That's a different thing. Even before, when a parent on behalf of the child can file a case, that's a different thing. But that it is like a Damocles sword. It is hanging on top of you for 18 years. And the second thing is, see, this limitation can be condoned. It is not an absolute law. Suppose a patient can, or a complainant can convince the judge that because of some reason he could not give a case and the judge is convinced, he will say, no problem, you can file. And as I said, consumer protection codes are all favorable to the complainant. So maximum they will allow. And this limitation period, practically, it is not very much valid. Now the procedure, suppose a person gives a case to the court, the judge will see whether whether there is any, it actually stands. Then he will give a notice to you. It will come to you, and you have to reply within 30 days. That is called as a written statement. Maximum you have a period of only 90 days to reply. If you don't reply, it is as if, it will be just decided based on whatever the patient says. You will not have a say. Okay. So that 30 days period is very important. And the problem with all these things is when a case comes against you, it is your head that is hanging. The lawyer, they have 100 cases. It is not only your case. You have to go behind the lawyer. And as medico-legal cases, they don't know anything about medicine or anything like that. So you have to keep on writing. It's a lot of stress. You have to keep on pushing them. Make sure they file the reply within 30 days. Okay, because like many of the lawyers, like income tax, the previous day they will say, doctor, tomorrow is the day for filing. They'll tell you like that. So all these things, you should be very careful. And once the reply is sent to the defendant, there is something called as a rejoinder. He will give you a reply back saying that, whatever you say is wrong, etc., etc. And then comes the court proceedings. Now, if you look at the National Consumer Protection Forum and all that, there is something called as an interrogatories. Now, you don't have to go there and answer questions. It is all in the written form. The patient or the complainant can give a set of questions which the doctor has to answer. The doctor can give a set of questions. And the same thing to the witness also, or expert witness also, you can give a set of questions. And all these things, and based on all the data, the judge will sit and decide upon the case. So it is like that. So in a way, if you go to the National Commission, you don't have to go to Delhi every time, because most of them are through interrogatories or written things. But the importance is, it is your case, it is not the lawyer's case. So you have to be very, very careful. You have to go behind the lawyer. You have to make sure all the deadlines are met, because lawyers, they are seeing hundreds of cases like this. For them, it doesn't matter. So these are the things I was telling you. And suppose you lose a case in the district forum, you can go to the state forum. If you lose again in the state forum, again you can go to the national forum. And if you lose a case in the national forum, you have to go to the Supreme Court. So that is the way. And if Supreme Court against you, finished. That's it. Okay. And any appeal should be filed within a period of 30 days. And if you file an appeal, actually rupees 50,000 or 50% of the amount decreed has to be paid to the court, and then only you can file a appeal. So this is the main thing. I said law favors the vigilant. So you have to be very careful. Then precautions. Take a treatment consent form. That is because when the patient comes to you, you can take a form. I agree to all the treatments that are given. I'm happy, etc., etc. Like in NABH accredited hospitals, you have that. And be truthful and frank. Don't try to pacify the patient. Like, he should not feel sad hearing the disease. So he'll say, no problem, you're okay, okay. Don't have that attitude. Be very truthful and be frank. And don't hesitate to investigate. Do MRI, CT scan, whatever you want, you do if you have a doubt. Don't say that patient doesn't have money to spend, so I thought I will not send all the investigation. Don't be like that. And consent forms, and keep records safe. Very, very important. Because I told you, even after 18 years, they can give a case against you. And when somebody gives a case against you, you won't even remember the patient. Then how are you going to defend yourself? Everything you have to depend on whatever the patient or the complainant says. So the law of limitation says that for OPD only you have to keep for 2 years. And for IP patients only 3 years you have to keep the record. But in truth, in reality, it is not like that. Whatever records, in whatever cases you are doubtful, keep the records with you forever, because you don't know when something is going to happen. Thank you.
Ready? Any comments? So he has given the outline of this thing. You understood why people are not going for civil cases. Suppose you ask for 10 lakhs, you have to keep 1 lakh in the court. That is for court fees and this thing. So if you lose the case, that money is gone. That is why nobody goes for civil cases.
Yeah, when you told about the definitions, then I was a little relieved, because everything is not negligence. But as the talk went on, I get more and more scared. That's all.
See, just one or two things. As for the young, hardly any youngsters here. All those are practicing ophthalmology, you have to join the professional potential scheme. It's a very good scheme by the IMA. There are very few cases where the IMA has lost. And number two, if you get a legal notice, get in touch with the representative, district representative, before you send a reply, and do not panic. And a consumer forum, many of the appointees are political appointees. The professionals do not have any say there. They will arbitrarily give. If you go for a civil case, you have to deposit 10% of the amount, and you lose the amount if you lose the case. Here, they don't lose anything. Unfortunately, he is a Malayali who is settled in Trivandrum, was the Union Civil Supplies Minister, who brought us under this. We are not under this consumer forum.
So I will start my talk. I think Ashok has, I hope Ashok has not scared you about the big bad wolf. So I will give you some other aspects of medical legal cases. This is what we should all know. So if something has to be called as a medical negligence, there should be 3 points. One is duty, second is breach of duty, third is resulting harm. If you do something and there is a breach of duty, but there is no harm, that person cannot go and say that I have been this thing. So these 3 points are there in any case. Duty, you have a duty when the patient comes in for the contract, and that is breached, then there is a harm. So these 3 things are mandatory to constitute a medical negligence. So Ashok has clearly explained what is civil proceedings against doctors, what is criminal. Then I will just tell you a few things about criminal proceedings. But before that, there are 2 IPC that we should all know, Section 80 and 88. So IPC, Indian Penal Code, 80 and 88. So nothing is an offense which is done by accident or misfortune and without any criminal intention or knowledge in doing a lawful act with proper care and caution. So most of the things that we do, we can have this Section 80 IPC. Then 88 IPC says, act not intended to cause death or grievous hurt or harm, done in good faith with consent for patient's benefit is not negligence. So these 2, 80 and 88, we should remember that these are our defenses. Then IPC, as I said, it has come, we are following 1860 IPC, and for any criminal negligence, you need something called mens rea, or intention to do harm or guilty mind. So unless it is proven, you are not liable. So IPC criminal proceedings are now taken on the basis of 304A, that is IPC 304A. Even recently in Palakkad, you might be, the doctor, they wanted to arrest the doctor for a death in the hospital after death of a child and mother. So that is the situation. But now the dirty political games are there, where they will arrest the doctor and keep him one day and then just to pacify the media. So IPC 304 is being taken again and again by politicians and police. In Rajasthan, one doctor committed suicide, Archana, I think committed suicide because that politician made the police take 304A against the doctor and was arrested. So that is the situation. But you can always have protection based on some of the Jacob Matthew versus State of Punjab. Actually, this was the case that defined what is negligence. Negligence is a breach of duty. I have already caused by, I already told, omission to do something that a normal or reasonable man will do, or omission to do something. So this is, the definition of negligence has been given by this case. So medical negligence is defined as a medical professional's conduct or omission, failure to act that deviates from the standard care. So standard care has to be followed in all our cases. So that is all that you need to know. So it depends on the type of medical service offered, practitioner's expertise, training, experience, even the location. That's what Sasana sir was telling. Suppose I am a qualified person, but I don't have the latest, one of the latest instrument or something. If I don't do that and patient is referred, only thing it has to be referred properly. I don't, the person cannot say that I am negligent. So even the location and the workplace has a lot of things. Now, Jacob Matthew case, the Supreme Court has clearly said criminal case cannot be charged against a doctor. Chumma, just like that you can't do, unless there is a recklessness or mens rea. So, after that, there is just a reduction in the number of criminal cases. So, reckless treatment means what? Reckless treatment is probably you are drunk and treating. That can be reckless, right? You are drunk. Recently, we saw one, probably all of you might be having WhatsApp videos you will be seeing. So, if you are drunk and then treating a patient and something happens or something like that, that we don't do. So, reckless treatment in ophthalmology is very, very, very rare. So, criminal proceedings will be taken only if it is a reckless treatment and based on this Jacob Matthew state of Punjab. Suresh Gupta case, Dr. Ashok already told. This was a case where a 38-year-old man had nasal deformity surgery and there was aspiration from bleeding and the patient died. So there is a special board of eminent doctors were constituted and based on that their opinion was there was negligence but not criminal negligence. He was charged for civil but not for criminal negligence. For fixing criminal liability, the standard of negligence should be proven, it should be so high that it's gross negligence or recklessness, and so that it is a crime against the state. The civil negligence is between 2%, civil case is between 2%, but criminal case is the accused and the state. State is on the opposite side. So it should be at that level. So then only a criminal case can be charged. So every mishap or misfortune in the hospital or clinic or doctor is not gross act of negligence to try for culpable negligence. This is clearly mentioned by the court in this case. So it is not possible for anyone to take a criminal case or something like that on whatever happens in the hospital. Only problem that I said, there are a lot of political pressures and media creates a hell of this thing for pacifying that, and people, they take all these things. But criminal case will not stand in most of the cases against doctors. This is another case, Kusum Sharma versus Batra Hospital. Here also, the court clearly said that one professional doctor clearly is not negligent merely because his conclusion differs from another person, another doctor. I am treating like this, I am giving this injection, somebody else is giving that injection. So that doesn't mean that he is it doesn't mean negligence. So, and there could be a differential diagnosis. I am treating one condition, as Ashok said. So this also, these are some of the cases where we can court if we get a medical legal case. Now, after 1995 only, all these problems started because IMA versus VP Shanda was the classic case where the court observed that medical practitioners were not immune from a claim of damages on the ground of negligence. So Consumer Protection Act included doctors after this case. So this is one of the important case laws in the history of medical legal cases in India. So CPA started was enacted in 1986. Till 95 there was no problem, but after that doctors are liable by Consumer Protection Act. So there are a lot of aspects. Some people think that I am working in a government setup, so I am not liable for Consumer Protection Act. It is not like that. If the contract between the patient and the doctor is absolutely free, then there won't be any liability on consumer protection, based on Consumer Protection Act. In other words, I will tell you, in the hospital, they are collecting 2 rupees for the OP ticket. That means you are liable, or based on CPA. So don't think that since I am working in a government hospital, I am not liable. Only thing, you will be the third person accused. First will be the government of Kerala, second will be superintendent or something, and third will be your name. Only that will be the difference. And if there is a fine, that will be divided by all these 3 people. So that is the difference. Otherwise, another example I will tell you. I did a surgery in the camp, but patient can go to Consumer Protection Act, because in the camp You ask the patient to come to the hospital, they pay something for some one test or something they pay, or in the camp somebody else is paying. So that means it is not full free treatment. So there is a payment involved in one of these areas. So they can go for, even if you tell, they need only one receipt from taking a medicine from the hospital or something. So it is not. So even in camp cases, they can go for this thing. But don't worry about all these things. We'll go to some of the cases. I will talk on what is this stare decisis. It is called a judge-made laws. Every law is not made by the legislature. In law, there are three aspects. One is legislature, two is judiciary, three is executive. Who makes the law? It is the legislature, parliament. Indian parliament makes the law. Okay, Indian parliament. The judiciary, what it does, it interprets the law and gives verdict. And the executive, that is police, all these people, enforces the law. So this is the situation. So in India, the parliament can enact any law. Okay, day before yesterday you saw the paper that violence against doctors. The parliament is not proceeding with the bill. They passed an ordinance. Ordinance will stand for 6 months only. Passed an ordinance saying that violence against doctors are punishable by all this blah blah blah. Now they are not going ahead with the enactment of that this thing. So that is and yesterday in the one of the WhatsApp group somebody has said Ayush people can practice allopathy. So there is nothing wrong in that actually, because the law made by the parliament or legislature or state assembly has written Ayush people can practice medicine. So the court says okay, as per the law this is possible. So everything we cannot blame the court. Court is only interpreting the law. Another example I will tell you. Jallikattu was banned by Supreme Court. Still it is happening. Why? Jallikattu was banned by Supreme Court saying that it is a cruelty against animal. The following animals, 1, 2, tiger, all the animals, and under that there was bull. Okay. Now what the state did? They made an ordinance and removed the bull from the list. So Jallikattu is okay. Supreme Court is correct, state is correct, Jallikattu is going on. So this is how the law is being interpreted and enforced in India. So these are all just, I am deviating from the topic. But yeah, so as per the, regarding consumer protection cases, there is no law as such in this thing. But there are a lot of case studies, case laws, judge-made laws, stare decisis. And suppose the Supreme Court or High Court gives the verdict, it is binding as per the Article 141 and 142. If Supreme Court says this is this and cannot be charged, then that is binding to all. We can quote that in everywhere. So, for example, another example is Vishaka versus State of Rajasthan. There is rules regarding the sexual harassment against women in workplace, right? There is no law like that. But in this case, the Supreme Court said this has to be followed like this. So such a thing has to be reported and all. So it became a law. So that is called judge-made law or stare decisis. I will show, is health a right in Constitution of India? It is not a right. It is not a fundamental right. Article 21 of the Constitution says right to life and right to personal liberty. These are the two things, not health. But later, in 1989, there was a case, Paramananda Katara versus Union of India. This was a very, very landmark case actually. And actually person died after accident, after a road traffic accident. He was taken to one hospital, second hospital, third hospital, but nobody gave a care, emergency care. Patient died. So that time patient, this Paramananda Katara was a social activist and he filed the case, and Supreme Court has given clear mandate, that clear guidelines, that health, the obligation of state to preserve life and right to health become almost a fundamental right after that. So this is a judge-made law that has made health into a fundamental right. And so that is what I meant by judge-made law. There are a lot of, this is the most important thing, don't do anything outside the consent. This is another interesting case, Samira Kohli versus Prabha Manchanda. This is a classic case, everywhere it is quoted. Samira Kohli was a 40-year-old lady, had some, she gave consent for a EUA and endoscopy, I think. When the doctor did the EUA, there was a tumor. So the doctor removed the uterus or ovary, whatever. So she, after getting consent from her mother, this was an unmarried lady, getting consent from the mother, patient is in GA. Okay, and removed. When the patient woke up, she understood that ovary, uterus is gone, and she was going to marry a person. They gave a case. So in this case, the Supreme Court has clearly mentioned what is consent and what has to be done should be inside the consent. So I will give another example. All of us do that. EUA and enucleation. Okay, EUA and enucleation. Because GA we don't have to repeat. So these are all very tricky things. If suppose EUA, usually these are all children, that may not be a matter of concern, but you can take a consent from the father or mother. But if it's an adult, exploration or enucleation, like that, you cannot take a consent. So this is very tricky thing. They can go and you will be in soup. So take an informed consent and don't do anything outside what the patient has consented. After giving anesthesia, don't try to take consent from whoever is standing outside. So that is very important. This comes to play only in some general anesthesia cases. So this is one of the important landmark case. Then there is another one. Don't treat outside your expertise. It started from this Poonam Verma versus Ashwin Patel case. This was not connected with us because this was a homeo doctor who gave allopathy medicine and the patient died. So what the court has said is there's a degree of expertise for every person and don't treat outside. This is coming into a problem because now a lot of people are doing I will give an example. Just a lot of cataract surgeons are giving right, left and center all these injections. Suppose the patient goes, this is a retina case and retina treatment cannot be done. That case will be difficult to defend in the court. So intravitreal injections or something. But probably in a center where like a medical college where everything is available, you can consider this. But a single practitioner doing cataract surgery without any retina training, giving anti-VEGF injection. I had recently 2 endos given by a solitary cataract surgeon for CSR. So just if that patient goes, screwed. 100% they will be, if the case is lost. So outside, this case is becoming more important now. So take care that you don't treat outside your expertise. You define your own expertise and don't treat outside your expertise. Then this emergency care I have already told, Paramanta Katara versus Union of India. Many times the problem not in ophthalmology. Suppose a person comes, even in our OPs, with a multi-system trauma or something like that, you go, you don't stand here, you have to go to the medical. But at least put a torch light and see the eye and then give an antibiotic drops and send the patient, it should be fine. So this is important. Many places, no, we don't take. This only ultimately will create problem. You just look at the eyes and then give some primary drops or something, 2 minutes, and then send the patient to this thing. That should be fine. So every case has some implications in our routine life. Now, this is very important. Bad outcome of the disease is not our fault. Okay. So you do surgery, as he said, macular scar, you do a good cataract surgery, there is something. It is not our fault. State of Punjab versus Shivram was an important case, 2005. Post-sterilization, somebody became pregnant. So that person gave a case after sterilization. But the court has clearly said, doctor is not liable for the bad known outcome of the surgery when done with due care and competence. Okay, your surgery may fail. Retina detachment surgery, it may fail. It is not that you'll be all right always. So don't worry about these things. Don't worry about the outcome. If you have done a standard of care with proper referral and all this stuff, you don't have to worry about the disease. Your vision is bad, then. So extrapolation in ophthalmology is very, very important. This case everyone should know. So you will not be liable for all bad outcomes of treatment if you have done the treatment with due care and expertise. Now, then confidentiality of the patient. This is Mr. X versus Hospital Z. There was a case in Delhi. Actually, this was a patient was HIV positive. They knew the HIV status and then called fiancé, not married. that he is having HIV. That marriage was called off, and that person sued, saying that my confidentiality was broken, and gave a case. But the court says few things. It is on either side, when you should disclose, when you should not disclose. Suppose a person comes for a driving license, he is driving public transport system or a bus. We have cases, right? So don't ever sign, and actually you should inform that authority that he is driving. That we don't do because we don't have time. At least don't give the certificate like this. These are all important, especially driving license. And another thing that I have noted is many presentations. Now we are all doing presentations in the webinars, YouTube. Patient's face is there everywhere. Suppose a person goes saying that my identity was breached. What will you do? There is every presentation, somebody's face is shown, especially oculoplasty and all. At least the retina we will show only inside. So oculoplasty and all, everything is shown. I am repeatedly telling, you should not reveal the identity of the patient, or some masking should be there. Otherwise, they can go for this thing based on this confidentiality. Every patient has the right for confidentiality. So these are all something that I came to notice in the last couple of years. So that is, you can disclose the HIV status or blindness to the authorities because personal rights stop when public peril begins. If the patient is a risk for the public, you can always disclose. But make sure that it is not identifiable in public domain. Autonomy of the patient. Autonomy of the patient is very important. So in fact, this was Schlondorff versus Society of New York Hospital, 1914. This was the first case that gave opinion regarding the consent. This Justice Cardozo is a well-known figure. And what happened here, same case. Anesthesia consent was given, but the doctor removed the tumor. So Justice Cardozo said, every human being of adult years and sound mind has the right to determine what shall be done with his own body. And a surgeon who performs an operation without patient consent is an assault for which he is liable for damages. This was the first definition of that. After that only the consent became very important. So how to take the consent and all we can discuss later, because I am just giving an overview. So then that is regarding consent, Samira Kohli case and this Schlondorff. Then there is another case, Lakshman Balakrishna Joshi, Trayambek Godbole case. Here, there was a fracture of femur, and this was reduced under local anesthesia. Patient went into shock and died. So here the medical expert team was constituted, and they said it should be done painlessly under the general anesthesia. Patient was not given that, so he was found guilty. So what is important is what is advised by a body of experts. A doctor should follow what is advised by a body of experts. There are 2 laws also coming that I will show in the next couple of slides. So, for example, in India, intravitreal injection, how to give. There is a body of experts like VRSI or AOS have given some guideline. At least, even if you can't obey all the points, at least you should make sure that you are obeying most of the points. Some of them are very difficult to obey. So this will be, you can be taken as a proof for our support in the case. So this is something. In many cases where there is no guidelines written by the national bodies, an expert usually from the medical college or teaching faculty will be called, and they will be asked. Usually they will be giving a standard care. Last week we had a discussion in Cochin Ophthalmic Club. I am operating one case, I see after 1 week only. Is it okay after cataract surgery? Suppose that ends up in an endophthalmitis, and Mahadevan sir is called as a witness. What will sir say? 1 week is okay. He will not say that. Next day it has to be seen. That is the standard of care. So that doctor is screwed. So this is the body of evidence given by experts. So either it is a national level thing or an individual expert. So make sure that what you are doing is in tune with the practice of ophthalmologists in the country, in the state. So there is something called Bolam test. There are 2 tests actually, Bolam test and Bolito test. This everyone should know. This was in 1957, Bolam versus Fry and Barnett Hospital Management Committee. That time the court was in favor of doctors. Doctors were gods. So whatever they say in good faith is okay.
So this, what happened was, this patient was given that ECT, electroconvulsive therapy, without giving relaxants or something, and patient had a fracture. So court said, and at that time doctor said, everyone is doing like this, so I am doing like this. So court agreed, saying that the doctor has gone as per the standard of care given by other doctors. So Bolam test is applied even in India, even now. So whether that's the standard of care, then you are okay. So everywhere you try that whether you are doing the standard of care as per the guidelines. So that is Bolam. Later the court became little pro-patient or pro-consumer. In Bolito test, there was another one. A patient who had a breathing difficulty, I think it was a croup case or something, and died. The child died after that. Lot of experts were called. 4 or 5 experts said, I will not intubate. Other experts said, I will intubate. So there was a difference of opinion. So the court said, even if it is the standard of the standard of care, the doctor should act logically in each case. So the doctor was liable at that time, made liable. So after that, many cases they apply Bolito test for finding fault with the doctor. That is more patient pro-patient than pro-doctor. So be very careful, and the treatment should be logical. Even if you next day you see end of after next day, I mean cataract surgery, you see some cells and flare. You give increase the antibiotic, all this stuff, and 2 days later it worsens. And the patient goes to the consumer case saying that I was not given intravitreal injection next day. But if it is logical that you can justify your thing, you are saved. So I am just trying to extrapolate each of these cases in our scenario. That's all. These are all not cases. So intravitreal injections also, make sure that you follow the standard protocol and logic. Can a DME patient, a DME patient comes to you, you are advising injection. As per the guidelines, what is every month 1 injection, then every month OCT, then in 1 year 8 injections. These are the, but is it logical? It is not logical. So whatever is written in textbooks may not be practiced always. So all these things we should, whatever you do a logical treatment. So that is Bolito test. Recipsa locator, I already Dr. Ashok has mentioned. That means the evidence speaks for itself. This is a condition where the doctor has the burden of proof. Burden of proof means you have to prove that you are not guilty. There are cases like rape and drug. Suppose you are caught with little drug. If that is about 3 milligram of that drug, then you have to prove that you are not guilty. It is not the state has to prove that you are guilty. Okay, these are some of the cases. So avoid reckless mistakes which are res ipsa loquitur. So these are some of the cases that I would discuss. It's open. We have 5 minutes more, and we welcome you all for the August Ophthalmica. Dr. Meena Chakravarti is giving the Govinatha Menon Memorial Oration, and this is my personal invitation for Giridhara Institute 25th year CME. All of you are welcome. Thank you.
And he said 2 tests, Bolam test and Bolito's test. There is a 3rd test called modified Montgomery's test.
Montgomery. Because our topic is who is afraid of?
Afraid of, yeah.
So that is more scary.
Yeah, that is not practiced in India, in Singapore and other countries, where the patient should be informed about the consequences of your treatment, and it is up to the patient to decide whether he should take your treatment or not. Like you say, you have to do RD surgery. You just leave it at that. You should say RD surgery, there can be a complication, you can lose vision, this many %. Then patient will decide whether I should take this or not. If he was not informed, then
Montgomery test is even more stringent against doctors.
That is what.
We do, but we don't scare, no? Suppose an RD patient comes, do you say this will be this thing, this many eyes will become blind, this will become painful blind eye? I tell 90% will get some vision. Not that 10% will not get vision and become blind. But it is all in the consent. You should tell the pros about the treatment, cons of not taking treatment, and alternative treatment available. That is very important. That is very important. What are the alternative treatment? So these 3 points should be there in the consent. No. India, mostly Bolam, little Bolito nowadays people are applying. Even in that recips allocator case, Bolam test was given. It is not that you don't have to explain all the consequences.
Even the rare consequences. I mean, the Bangkok case was that. No?
Yeah, there is actually another case is there. Whitaker versus in Australia. A patient had a injury beyond that. So in India, you have to explain the common adverse effect and serious rare adverse effect. Okay. Serious rare adverse effect. Probably in cataract surgery, what are the serious rare adverse? Endophthalmitis, right? We are all worried about it. You can tell in 1 out of 10,000 can get endophthalmitis. You can tell. But we don't expect 1 person can get angiographic cystoid macular edema. Do we tell? We don't tell. So you have to explain all common adverse events and serious rare adverse events.
And consent means not just oral. No? You have to write it down.
Yes. Actually, that is a big topic. Consent itself is a big topic. Consent has to be written down with the patient's handwriting and signed by 2 people, 1 bystander and 2 witnesses. Ideally, the witness should not be related to you or patient, but usually the sister and 1 relative will sign. So, ideally, it should be written consent. But and there is a recent High Court judge from Delhi forms. Regarding consent. Filling of this thing, no?
Printed forms.
Printed forms is not acceptable. Even if you print, at the end you write that I have read and signed as a patient, at least that much. So, we are all going into that direction. Everything should be.
Thank you, sir.
Incident and politician is still alive.
It's a political. Even now, that Rajasthan case happened only recently, 6 months back. You cannot arrest a doctor based on criminal negligence on 304A, just like that. Now, police people are also little careful. But they want to pacify the media and people, they will just take the arrest. Young orthopedician, that also. But the problem is, I don't know, you remember one pediatrician from Calicut, retired pediatrician, very nice man, was arrested for examining a child. That he was charged POXO. Remember? POXO. So the policeman can give some vague against humility, against women or something like that and arrest the person. It is all that police people who are sitting there, they will decide. So if they want to trouble you, they can trouble you. But it will not stand. It will not, criminal negligence will not stand.
There was another incident in Delhi many years ago. Advanced liver disease. A doctor had given leave 52. Leave 52, many of us are eaten. And when they went to the court, they said, do you have the qualification, Ayurvedic qualification for this? No. How did you prescribe this? He lost the case.
Yeah.
Another one is a physician had palpated the abdomen of a girl. The class, the teacher said, if someone touches your abdominal area, you should report. This girl reported and this doctor was inside for
Actually,
2 days.
This Calicut doctor, I don't want to tell the name, very nice man. His life was ruined and none of the bloody newspapers gave this thing correction about this.
Nobody gave a correct
Nobody
version.
gave a correct version. Anyway, thank you for giving us 1 hour. Thank you.